Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utility Subcommittee. Today is Wednesday, March the 12th, 2025. It is 3 p.m. I'd like to call this meeting to order. Members, if you could go ahead and log into your device, and Madam Clerk, if you can put us on the board to take the roll. All right, Madam Clerk, can you take the roll?
Mr. Chairman, you have 9 members present.
Thank you. I appreciate that. Members, before we get started today, do we have any personal orders? If not, we do have a couple of housekeeping items, and that's item number 2, House Bill 757 has been taken off notice at the request of the sponsor. Item number 3, House Bill 1047 has been rolled 1 week at the request of the sponsor. Item number 4 has been rolled 1 week at the request of the sponsor, which puts it on the special calendar. Item number 8, House Bill 452 has been rolled 1 week. All right, members, we do have a calendar, so let's go ahead and get started. We'll go ahead and take up item number 1. That is House Bill 1309 by Representative Martin. We have a motion and a second. Left you hanging there, sponsor, didn't it? All right.
Close.
And Representative Martin, you do have a couple of amendments.
Amendment with it. Yes, sir. It is 5195.
Okay, that's what I'm showing too. Can I get a motion in a second? All right. Tell us about the amendment real quick, sponsor.
Yes, sir. So this was what we worked on last week in committee together. So that was good to hear. We had put a 5-year sunset on this clause so we can come back and reassess it.
Stand by just a minute, sponsor. We're showing a 4-year.
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 9
okay.
minus 5 is 4. So thank you. I was looking at 29. You're right.
All right. So we're putting a 4-year sunset on that. Members, we've got a motion in a second. Do we have any questions on the amendment? If not, we're voting to put amendment 5195 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, you are recognized on your bill, and it's amended now.
Thank you, Chairman and Committee. So this is what we discussed last week. This legislation simply allows the Mega Site Authority of West Tennessee the opportunity to retain interest accrued as a result of the rates collected from the operation of their wastewater plant. We put this in play. They have to work without a deficit, so this would help keep them at neutral for this 4-year period, and then we'll come back and reassess if they can continue to keep that. With that, I stand ready for question.
Thank you, sponsor, for that explanation. Members, do we have any questions for Chairman Martin? If not, let's go ahead and vote. We're voting to send this bill as amended to full commerce. Go ahead, members, and place your vote. Has every member voted? Does any member wish to change their vote? If not, Madam Clerk, take the vote.
Mr. Chairman, you have 9 ayes.
Congratulations, sponsor. We will see you next week in full commerce. Your bill passes. I do not see Representative Alexander, so let's go ahead and move on. We're going to go out of order, members, to House Bill 1345. That's item number 7 by Representative Reeves. Can we get a motion? Can we get a second? All right. We're on your bill, Representative Reeves, but it looks like you do have an amendment. Can you clarify your drafting code for us?
Thank you, Mr. Chair. Yes, drafting code 005102.
That's what I'm showing as well. Does that make the bill or just amend it?
It rewrites a section of the bill.
Okay. Members, let's get a motion in a second on the amendment. Okay. Do you want to describe that or go ahead and put it on the bill? And
go ahead and put it on the bill if you don't mind.
Members, we're voting to amend House Bill 1345 with Amendment 5102. All in favor say aye. All opposed say no. The ayes have it. Congratulations, sir. Your bill is amended. You can describe it now.
Thank you. So this bill amends the period of time a property owner has to terminate a tenancy, a residential tenancy, from 14 days down to 7. That brings us in line with all the states around us. The 8 states around us have an average of 6 days time period. And I know we care a lot about being competitive in the business environment. And I think this helps us do that here in Tennessee.
Sponsor, I appreciate that explanation. Members, you've heard the explanation. Do we have any questions for the sponsor, or are we ready to vote? Representative Hardway, you are recognized.
Thank you, Chairman, and good afternoon to the sponsor. Um, what impact does this have upon leases? Is this for, well, I'll leave it at that. What impact does it have upon leases?
Sponsor, you recognize.
Okay, I
Written
appreciate
contracts.
that question very much. And so what this allows to property owners to do is exercise their legal rights in the case of a non-payment of rent or damage to the property or another violation of the lease.
Representative Hardaway.
Thank you. So the opportunity to cure the violation of the lease is reduced from 14 to 7 days, no matter what that breach might be.
In those,
Sponsor, you recognize.
sorry, thank you. It does in those instances, yes, sir.
Representative Hardaway.
All right, thank you, Chairman. Unless you can give me some legitimate reason, I just don't think, and I'm a landlord, I just don't think that's fair. So right now I'm leaning away from your bill.
Sponsor.
Well, I'm sorry to hear that, but let me explain a little further. The first person to know that rent will not be paid is a tenant. The first person to know that damage has been done to a property is the tenant. And the first person to know that there is a safety threat, which is the third category of things this applies to, is the tenant. And so this just allows a landlord to go to remedy that in court a week earlier than they have been allowed to in this state. And generally, once you go and file something in court, it's 2 or 3 weeks later that you get hurt in court. So I think that it places a burden on our property owners and would like to bring that in line with the other states around us. But thank you for your comment.
All right, thank you for your explanation.
Chairman Powers, you recognize.
Thank you, Mr. Speaker. I move previous question.
All right, we've got objection. So I'll tell you what, let's, instead of voting on this, let's go ahead and let a couple more people speak and then we'll take the vote. So I do have Chairman Clemens up next. You recognize Chairman Clemens.
Thank you, Mr. Chairman. I appreciate that. And so I certainly understand the intent of the legislation with regards to damage, with regards to posing a threat. I just wish we could pull out the part about refusing or neglecting to pay rent, because generally it's not always refusing or neglecting to, it's just the inability to pay rent. Sometimes it qualifies under that. And because Tennessee code allows a tenant to cure that within a time period, the reason we have 14 days, or part of the reason we have 14 days, is because traditionally pay periods are 14 days. Most people get paid every 2 weeks. And so that 14 days was intended to allow a pay period to lapse so that we could tell whether or not the tenant was refusing to pay rent or he or she was unable to. So I would love to pull out the first part with regard to refusal to pay rent. And if you want to, and rather, if 7 days, I understand with posing a threat or damage to the property, but that 14 days is there's a reason for that with regard to the failure to pay rent. So I would love to see that amended, but if it's not, that's my concern with the legislation.
Sponsor, go ahead.
I appreciate those comments. Failure to pay rent is the most common reason that a landlord or a property owner would go to a court to get a remedy of some sort. I have owned properties in several states. Texas, I know, is 3 days, and so is Georgia, and so is Arkansas, and so is Mississippi. I intentionally moved this from 14 to 7 for the reason that you mentioned, because often a pay period or a paycheck comes within a certain amount of time. And in my experience, property owners generally don't want to have to go and exercise a remedy at all. They just assume that the rent get paid. And I think a tenant can certainly do that before the court date. And that's been my experience in real life.
Next up, we have Chairman Bricken. You recognize.
Thank you, Mr. Chairman. More of a, this is a question.
There it is. The question I have is, if the lease contract, it already has termination provisions in them, most of them for failure to do this. Is this legislation for leases that are silent to those conditions? Because it seems like the lease agreement would have covered the provisions that the landlord would want.
Representative Reeves, you recognize.
Yeah, I appreciate that question. State law supersedes what you've got in a contract. So property owners within Tennessee, right now, it reads 14 days. They have to abide by that 14 days.
If they're currently in, the current leases would stay until they terminate?
Sponsor, you
Material?
recognize.
Thank you.
It would move to 7 days after a certain period of time when the law goes into effect, which I have as July 1st.
You good, Representative Birkin? And sponsor, I'm going to ask real quick. This applies to those counties in the Uniform Landlord Tenant Act and the non-counties. This is statewide, right?
Yes, sir, it does. It applies to both.
Okay. Next up, we have Chairman Lafferty. You're recognized.
Thank you, Mr. Chairman. For the sponsor, I just wanted to let you know, in my time up here, my income, my real world income is from my rental properties, and I have made it a practice not to vote on bills that may or may not be perceived to have a positive or negative impact on me. So I just wanted you to know that. Thank you.
Sponsor, you recognized.
Thank you. I appreciate that explanation. Thank you.
Chairman Powers, you're recognized.
Thank you, Mr. Chairman. I'm going to move previous question again.
Previous question has been called. Members, we're voting on House Bill 1345 as amended. All in favor, vote aye. All opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote, please.
Okay.
Mr. Chairman, you have 4 ayes, 4 nays, 1 present not voting.
The bill fails. Sorry, sponsor.
Thank you, Chair and Committee.
Members, that brings us back to item number 5. That's House Bill 860 by Representative Alexander. We have a motion. We have a second. And sponsor, I do see an amendment. What drafting code are you showing?
One moment. 2284. No. 2895. No. 3872. Sorry.
That's what I'm showing. Members, can we get a motion
I have
and a
that one
second
in
on the
here too.
amendment?
Sorry, guys.
Members, the motion is for amendment 3872. Do I have a motion on that? And do I have a second? Okay. Sponsor, do you want to talk about your amendment, or you just want to go ahead and put it on the bill?
We'll just put it on the bill.
Okay. Members, we'll vote to put amendment 3872 on House Bill 860. All in favor say aye. All opposed say no. The ayes have it. Sponsor, you are recognized on your bill.
Thank you. Currently in Tennessee, law requires funeral director applicants to complete a 2-year program of school and apprenticeship. Under the proposed changes in House Bill 860, the pathway to licensure would become more flexible by permitting applicants to concurrently complete their apprenticeship alongside their educational requirements, which consist of at least 30 semester hours and 45 quarter hours from a school accredited by the American Board of Funeral Services. The ability to simultaneously complete coursework and apprenticeship requirements represents a significant modernization of the funeral director license pathway, particularly benefiting workforce development and career changes. This concurrent approach makes the profession more accessible by reducing financial barriers, accelerating entry into the profession, making the career more attractive to mid-career professionals, and maintaining professional standards.
Sponsor, thank you for that explanation. We do have a list starting here. I've got Chairman Birkin. You recognize.
Thank you, Mr. Chairman. And to the sponsor, more of a curiosity question. Training of funeral directors in Tennessee, do we have university programs for this, or are they have to go out of state? Tell me a little bit, if you can, about training
We do have programs.
Representative Alexander, you're
Sorry,
recognized.
Chairman. We do have programs in the state of Tennessee. Gumpton College right here in Nashville, for example, is one such school. And they do this. In fact, we just had 2 in the funeral home that my husband and I previously owned until 2022 when we sold it to our employees. And they 2 of their children just did it, but they did 2 years of apprenticeship first, then they did the year. And so this just helps be able to do an apprenticeship at the same time you're going to school.
Representative Birkin.
Other than the Carter Academy, I'm not sure what the school is. Are there others in the state? I mean, just again, trying to.
Yeah, I think 2 or 3
Okay, that's
in
fine.
different places. Okay.
Chairman Lafferty, you recognized.
Thank you, Chairman. Sponsor, I was just curious, if they run it concurrently, is there a minimum number of work hours that they are supposed to get? Does running concurrently interfere with that, or how would that look?
They
Representative
still have to
Alexander.
do full-time. They still have to do the same 2 years as an apprentice. They're just doing their college on one of those years. There's college requirements, there's schoolwork.
Chairman Lafferty.
All right, thank you. Thank you, Chairman.
Members, I don't see any other names on the list. So the question's been called. And so we're going to go ahead and vote on House Bill 860 as amended to send it to full commerce. All in favor of vote aye. All opposed, no. Madam Clerk, can you take the roll, please?
Mr. Chairman, you have 8 ayes.
All right. House Bill 860 passes. It'll be in full commerce next week. Congratulations, sponsor. Members, that brings us to item number 6, House Bill 972 by Representative McCalman. We have a motion, we have a second, and Representative, I do see a couple of amendments. Are we putting both of those on?
Yes, Mr. Chairman, we are.
Okay, let's, the first one that I'm showing is 3869. Does that sound right?
That does sound correct,
And
sir.
that one needs to go on first, correct?
sir.
Okay, we have a motion, we have a second. Do you want to describe it or get them both on there before you?
I'll just get them both on there.
Okay, members, we're voting to put Amendment 3869 on House Bill 972. All in favor say aye. All opposed say no. The ayes have it. And then the next drafting code I'm showing is 4157.
That is correct, Chairman.
Can I get a motion? Second, okay. Members, we're voting to put Amendment 4157 on House Bill 972. All in favor say aye. All opposed say no. The ayes have it. All right, sir, you were on your bill. It's completely amended and you're ready to talk about it. Go ahead.
Yes, Mr. Chairman, members, and for the 3rd time in a row, we welcome back the booting bill that has been notorious for me. So I'm hoping we get it right this year and call it a day so I don't have to look at this one again. But that being said, it's essentially, basically it's a cleanup bill. It's clarifying some of the muddy language we had on towing with regards to signage. Specifically with regards to towing requirements on private property open to the public. And this was requested by the Towing Association. So they are in support of this bill with the as amended. First, it revises the signage requirements for properties where immediate towing is enforced. Under the amendment, signs must display the name and telephone number of the garage keeper authorized to tow vehicles from the premises. Secondly, it clarifies the towing authority for private property owners. If no signage is posted, the owner may immediately tow any vehicle that has been unattended for more than 12 hours, is creating a hazard, is blocking access to public or private property, or is parked illegally. With that, I stand ready for any questions y'all may have, and I would ask for a positive vote on this.
All right. Thank you for that explanation, sponsor. I do see Chairman Clemens' hand. Go ahead, Chairman Clemens.
Thank you, Mr. Chairman. And this is 2 amendments. Does this still prohibit any person from booting a motor vehicle under any circumstances?
Sponsor, you recognize.
Thank you, Mr. Chairman. Chairman Clemens, last year we effectively banned booting in the state of Tennessee. Nothing changes with regards to that. We did leave open a last year we basically said that any municipality that wanted to create a booting ordinance could do so, and to maintain it, nobody did. So we're wiping that out altogether and just leaving it banned as a state. So yes.
Chairman Clemens.
Thank you, Mr. Chairman. So yeah, I think there had been concern communicated to some. I just learned of this from a constituent who runs a rather large housing development in my district, that they were able to successfully prevent people from illegally parking because it's near a commercial district in my district, and by using the booting. And it was more convenient because if you walk outside and your car's going, you got to go through a whole process, got to go find, whether it's posted or not, go find your car, get it out, get a ride over there, as opposed to booting where you can call, you might have to wait an hour or two, but your car's there and, you just wait to get it. And so they had issues and concerns with that being prevented entirely. So I just want to share that concern with you. And because it's my constituents' concern, it is now my concern. Thank you.
Sponsor, you recognize.
Thank you, Mr. Chairman. And Chairman Clemens, I could certainly respect that. This actually originally came out of an instance in downtown Nashville where a young woman got off work at a convenience store and went into a paid parking lot where she was authorized to park there for free. And a tow driver came up, put a boot on her car, and refused to take cash. We actually addressed that in 2023. Last year, we had in Shelby County, we had various trucking companies, including FedEx, that were booted and then towed in a predatory fashion and charged exorbitant amounts. We had an attorney here last year who was out to dinner with his wife and was a little late on his parking. And Representative Barrett is saying that was not him, but he was out to dinner with his wife and 10 minutes late, came out, updated his parking, no boot. He's back 2 weeks later. Parking was not expired, but there was yet a boot on his vehicle. And he called the company to say, wait, I'm not expired. They said, well, that was for 2 weeks ago when we didn't get you. So what we eliminated it because there were far too many cases of predatory booting and resorted to utilizing the towing industry as a means to circumvent that.
Chairman Clemens. go
Yeah,
ahead.
thank you, Mr. Chair. And I understand that. And I supported that bill to clean that up and put restrictions around it. And I think, even if we allowed booting, I think there should be restrictions, saying when you can do it, when you can't do it, and how much you can charge for it and so forth. I think that'd be entirely appropriate. But under the bill as written, I mean, my car could be in a parking lot 10 minutes past the time and it could get towed. And so under this law, so I understand the concerns and it's frustrating. I prefer to get a ticket, to be honest with you, if I'm going to get charged. But anyway, my concern is the prohibition on the booting for that reason.
Sponsor.
Thank you, Chairman. And Chairman Clemens, if you're in a paid parking lot, it's not a matter of being there for 10 minutes and being towed. The immediate towing speaks to private property where it's not open to the public, where someone is essentially come up and parked in your driveway, and you can have them towed immediately with that. If it's in public area or it's a paid parking lot, there's last year we put stipulations in place that regulated the timing with towing. So.
All right, members, I don't see anyone else on the list, so let's go ahead and vote on House Bill 972 as amended to send it to full commerce. All in favor, vote aye. All opposed, no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote. All right,
Mr.
congratulations, sponsor. House Bill 972 is moving to full commerce. It passes.
Thank you, Chairman and Committee.
Members, that brings us to the end of today's calendar. So without objection, this meeting is adjourned.